Thank you very much. Your work done and well done. Thank you very much. Rwanda being a country which attracts investors, and as you may know, it is the second best in doing business and the most reformed country in the world, according to the World Bank doing business. So this center lasts for 7 years, Kigali International Arbitration Center, which was launched in 2012. The center itself, at the beginning, what was the priority to make a center, a workable center at the beginning? So we agreed on a 4-year strategy, which most of the time focused on the 5 pillars. One was training of judges and lawyers, including other professionals. We focused much on judges. As a sophisticated arbitrator in the room, you know the role of judges. And then we also focus much on learning from established center, as well as the first generation of arbitrator, especially of the continent at the time. We developed a marketing and communication strategy. We also conducted a baseline study to know what are the issues to set up a measurable indicators, especially the perception of the users, right from the beginning, so that we can monitor the users. It's very important, those who are running the center, have the perception of users of the center. Ended, we focus on building infrastructure. Infrastructure, I mean here, is building, but as well to develop policy, arbitration practice note, mediation policy, but also major reform like a reform on visa. As you may know, Rwanda is the country where anyone in the world can jump in the plane and come to Kigali without visa, without application to the visa. It is very important, and it has played a big role in the little we have achieved in the center. So now, what are the results after 7 years before I conclude on involvement of the center in investment arbitration? The result today, after 7 years, the case load is 132 cases, with 36% being international arbitration cases. Some may say it is few cases, 130 after 7 years, but since in this room we have researchers, I will invite you to go back and check among the top 5, starting by ICC, London, and check the case log for the first 20 years of ICC. I'm sure you'll not get 30 cases. The point I'm trying to make here, building an arbitration center, it takes much more time. It takes time for people to use the center and to believe that the center can make it. So another result is, which is very important and which is also linked with the role played by the center in training judges and convincing the judiciary of the role of arbitration, is today Kia have almost 72 awards, and none of the awards have been set aside in Rwandan court. Whoever tried to set aside the award, the judge have confirmed the decision of the arbitrators. Among the 132 cases, there is also 5 emergency arbitration. The party to international arbitration cases are from Burundi, China, Ethiopia, France, India, Italy, Kenya, Pakistan, Singapore, South Africa, South Korea, Rwanda, Spain, Switzerland, Turkey, Uganda, USA, and Zambia. So those are party to the 36% of international arbitration case, which almost represent almost 50 cases. We have a building, well set. We have trained professionals, judges, at the level of, we use the model of CIARB, where we have associate, member, and fellow, not only training the local, but also in the region to make sure that you have a pool of people who can conduct properly the proceedings. So before I conclude with what we have learned and which can be perhaps useful despite the challenge of today of the center, about the topic of investment arbitration, the involvement of investment arbitration, this case cited here, the report of the case law of the center does not make any distinction between whether a case concerns an investment case. It's only the precise, the international arbitration case. But as a lawyer, we have been involved in negotiation of investment contract. In 2014, the government of Rwanda have developed a ministerial order which has been published in the official gazette. And among the things was that ministerial order concerned the drafting, the negotiation, signing and managing international contract, and there is a provision which imposes if any of Rwandan negotiator to consider the use of KIAC. Failure to do that, it is only the Attorney General office to make a decision, but all negotiators around the country, the directive is to impose KIAC, and failure to do that, the Attorney General have to take a decision. From my experience, I have been involved in almost, for the last 2 years, in 10 investment contracts. Almost, apart from one, 9 of them considered the use of KIAC. Because when they finish the negotiation at Rwanda Development Board, when an investor is not happy of using KIAC, now they need to take another process to take it to the Ministry of Justice, and investors are not happy with that. And considering the data they have here with the center, they don't have any problem of using KIAC. So that is the experience we can share for the moment about investment, the involvement of KIAC in investment arbitration. Just to conclude, what we have learned from the center present here and for people like in Djibouti, we're discussing about setup of the center, building an institutional arbitration center or promoting a new arbitration center to get the case, it takes so much time. Don't expect to get cases in 3 or 5 years. You need to be patient, you need to invest in communication, you need to invest in marketing the center. When you see the statistic, the budget of big centers, the marketing and communication is more than 50% of their budget. So those are considerations when you are strategizing in building the center. Again, when you are defining your vision, your strategy, you need to include all actors. Actors, I mean judiciary, policymakers, professionals, and user of the center. Policymakers are very important. For example, the discussion around the visa issues. You can't do anything as a center when you don't have government which is supportive to make sure that such policy pass. So arbitration is not a legal concept or a form of justice. It should be taken as an industry. Is bringing in the country, see ICC with ICC we're trying to move to Switzerland, those who are informed about the whole process, how the debate went, but you understand that it is a market, it is an industry, it's beyond only the legal form of justice. What is very crucial from the little experience we had is you need to monitor how users perceive the development of the center through survey. A continuous survey almost every 5 years can be a good practice to make sure that you move on. Of course, the whole infrastructure of the country, zero tolerance to corruption, visa, friendly legal environment, again, putting the right person at the secretariat. Putting the right person at the secretariat. When you see ICC, when you see London, for those who have been doing some studies around those centers, the day you have a Secretary General who cannot make it, who cannot talk to the Chief Justice, who cannot talk to the President, then at the end, the center will collapse. You need someone with profile who can talk to everybody, who can be the master of arbitration within respective jurisdiction. So in conclusion, KIAC remains a young venture with many challenges, but however, the center have a reputable spreading and a future which might be brighter. Thank you very much.
Thank you, Thierry. We are going to continue this experience of investment arbitration in some arbitration center, and we are lucky to have Annette Magnusson, who is the Secretary General of the Arbitration Institute of the Stockholm Chamber of Commerce, and as the SCC is one of the arbitration center who is dealing with investment arbitration. So Annette will be happy if you can share what is going on with investment arbitration and how commercial arbitration center can manage to maybe take this part of the market. Thank you, Annette. You have the floor for 10 minutes. Thank you.
Thank you very much, and thank you so much to the FAA for the invitation. It's also my first time in Cameroon, so I'm very, very pleased to have the opportunity to come here. And I'm sure that some of you in the room might be wondering what someone from a fairly small city in a very tiny country in Northern Europe is doing here, talking about investment arbitration in Cameroon. I would be, if I were you. And hopefully, after I have finished here, you will sort of get a sense of sort of why I have been so kindly invited to share our experience here at the SCC. So, I will speak about arbitration in Sweden, very briefly, and sort of the universe of arbitration in Sweden, and I will say a few words about the SCC as an institution, and then I will dive into investment arbitration at the SCC. So I will throw a lot of numbers at you, which brings me to ask, do we have a presentation? Oh, we do. Let's see, does it work? Do I have a way of controlling the presentation myself? Maybe if I can just ask them for picture-to-picture. Is that doable? Okay, very good. So, starting off then sort of with the SCC story and who we are as an institution, we come from a slightly different perspective than my colleague Ricky Gali, and I must say I'm very impressed by your numbers. 132 cases at KIAC after 7 years. I can assure you that the SCC in Stockholm did not have as many cases after 7 years. We were founded in 1917, so we celebrated our centennial 2 years ago, or 3 years ago now. Time runs quickly. We used the opportunity, as we were celebrating our centennial, to really celebrate arbitration as a phenomenon. We did this through a number of initiatives, and you see some examples of this in the picture up to the right here. Well, anyway, I will just speak anyway, and we will see what you see. This is in the second picture, if it's possible to take it to the second picture. So what we did, we had a seminar where we really targeted arbitration as a tool for peaceful resolution between states. I think arbitration has demonstrated throughout the centuries its enormous capacity of being a bridge builder, also in very, very complex political situations. And I think the entire framework we see in international arbitration as illustrated and as reflected by the important instruments of UNCITRAL, they demonstrate the government's will to find common ground for rule of law-based resolution of disputes. So even in situations where governments were very strongly at conflict with each other in terms of politics, in terms of economics, in terms of even culture, even in those times, governments were able to sit down around the table and agree what constitutes an impartial resolution of disputes. And this, I think, is one of the strengths of international arbitration. And this is something we tried to celebrate during the centennial in Stockholm in 2017. So this is one way that we sort of approach the field of international arbitration. We sort of want the institution to be an ambassador for international arbitration and really explain to decision makers why arbitration matters. Also in times when arbitration has been criticized, and this is something we have seen in recent years. Now, we could not be a voice for international arbitration in Stockholm if it were not for sort of the arbitration biosphere that we have in Stockholm. So we have, since then, 1917, developed in Sweden a large group of professionals that are very devoted to international arbitration. And it became even stronger after the 1970s. In 1977, the Soviet Union and the United States reached an agreement that in their commercial relations, which they had also at that time, even at the height of the Cold War, in their commercial relationships between the two superpowers at the time, they would opt for arbitration in Stockholm as a resolution for disputes. And this really became the starting point for the international cases or the international content of the SEC activities that we're seeing today. Because it sent a very strong message to the world on the strength both of the legislation in Sweden, but also about the professional or the lawyers' skills, and also by the support of the courts in Sweden, given the way that arbitral awards were and still are respected. So this was the background as we moved into sort of the biosphere of arbitration that we're seeing today, how the number of arbitration specialists could really grow in Sweden. But adding to that, I think it's important to have more than just a practitioner, so to speak, and an institution. So we have two universities in Sweden that offer very popular master's programs, one in international commercial arbitration and one in international investment arbitration. And this has added a layer of the biosphere of arbitration in Sweden. These students are really, really brilliant students, and they come from literally all over the world, including African countries. And they come and spend a year at the Swedish university, and they go out and they are fantastic ambassadors for arbitration and for Swedish arbitration in the end. So this has really contributed to the role of Sweden in international arbitration. I think it's also important to have a modern arbitral legislation in a jurisdiction that aspires to be a seat for international disputes. That's also something that we need to work with constantly. I think the world is changing, so even if we did have a fairly modern legislation before, last year we had it modernized, really to upgrade it to meet the standards. International business life is really changing at a very, very fast pace, and it's becoming more and more complex and more interconnected across barriers, across borders. And this in turn gives rise to very complex and difficult disputes. This needs to be reflected in the way we regulate the arbitration procedures, both in the rules, but also in the legislation. So this is a discussion we're having with the legislator regularly. So going specifically then to the SEC and what we do, in a nutshell, we do mostly commercial arbitration. But we also do, of course, investment arbitration, and this is why I'm here. SEC is the second largest institution globally when it comes to administrating investor-state arbitrations under our own set of rules. Now, we have heard from ICSID here, and ICSID by far, of course, is the largest institution globally for the number of cases. And if you're looking at the statistics as published by United Nations Conference of Trade and Development, UNCTAD, which they do annually, we can see that if you look at the numbers, they have not yet been published as of last year, so I only have the numbers as of 31st of December 2018. The number of, and these are cases that are in the public domain, so the number of ICSID cases, if you would include ICSID cases and additional facility rules, were 568. The second most commonly used rules for investor-state arbitration is ancestral arbitration rules, and they had 295, and the SCC had 77, which is no other institution in the world comes anywhere near. And this is a unique role for the Stockholm. If you look at the institution administrating dispute, because it's one thing what kind of rules you're using in the dispute, and then who is administrating the dispute. And these are also numbers from UNCTAD, but also complemented with our own internal statistics, because not all of the cases handled by the SCC have entered the public domain. The number of cases administered by ICSID as of 31st December 2018 was 594. And the number handled by the PCA in The Hague, 136. And the number of cases administered by the SCC in Stockholm was 106. And again, there is no other institution that comes even close. But there is a large number we do not know if anyone administered, and if so, what institution that was. So you might then ask, how come the SCC in Stockholm sees so many investor-state cases? Well, the immediate reason for that is that the SCC or Sweden has been included as an option for investor-state arbitration in at least 120 bilateral investment treaties globally. And we are also an option under the Energy Charter Treaty, where the SCC is one of the options for investor-state arbitration together with ICSID and the ancestral rules. And I was just looking now for the number that was sent to me when it comes to the African BITs. So we know of 17 BITs involved in African states where the SCC is included in investor-state arbitration provision, and 2 of them are OHADA countries. So this is sort of the background as to why we're seeing so many investor-state cases at the SCC. These cases are handled under the SCC rules, the main arbitration rules. So we don't have a special rules for investment arbitration. We do, however, manage them slightly differently in the sense that we recognize that governments are large organizations. So they, for example, they will need more time when it comes to the administration of the dispute. And we will have, for example, longer time limits for governments to respond on submissions. And there are similar adaptations that are being made when we handle the cases with governments involved. There are specific rules applying, though, only to investor-state cases in SCC rules, which are included in an appendix under the rules. And in essence, they relate to the number of arbitrators, which is always 3, and rules on transparency. And they reflect the ancestral rules on transparency when it comes to the involvement of an amicus brief in investor-state cases in Stockholm, or the involvement of a non-disputing treaty party. And the language here again illustrates or reflects the ancestral rules on transparency. The main rule in our cases, investor-state cases at the SCC, is that the proceeding is confidential, but there is nothing preventing the parties to add on the ancestral rules on transparency if they would like to do that. So we have specific instructions, if you want to call it that, where parties can actually get help to what they should do if they want to have an SCC arbitration in combination with the ancestral rules on transparency, to have that transparency as foreseen under the ancestral transparency rules. Just then, a few words about the nationalities. I have mentioned the number of bits that we see at the SCC and sort of the background to why we see so many investor-state cases. So in the 112, I should say, by